Are you an employer who wants to know if you can monitor your employees' emails, phone calls, and internet activity? Or are you an employee who's wondering if your employer can do that to you? Well, you've come to the right place for the answer. My name is Jack Malley. I'm a labor and employment lawyer and litigator. I practice in New York and Connecticut for Smith, Buss, and Jacobs. Welcome to episode 3 of our video series, Making Employment Law Simple. So let's get right to the topic. Employers monitoring their employees. When I first heard about such a thing about 20 years ago, I thought there's no way in the world an employer could ever do that. And I bet a lot of you employees out there think the same thing. But they can. And that's the law pretty much throughout the entire country. And it's certainly the law in New York and Connecticut. So what am I getting at? That's old news. So you're probably saying to yourself, why are you bringing me this old news? Because we got some new news on this topic. Last month, the new governor of New York, Governor HOCHUL, signed into effect a new law on this topic that has 3 factors to it, 3 things in it that employers have to know. Number 1, if an employer is going to monitor employees, monitor their emails, phone calls, and internet activity, and this, by the way, is on the employer's devices. Now, effective May 2022 in New York, employers must give written notice in advance of doing that monitoring. Now, that could be by an email, that could be a written policy, or that could be a memo. Second, employers must also post a notice in the workplace so employees can see that if they're being monitored, they know about it. And that has to be, it says it right in the statute, in a conspicuous place in the workplace. That's a place like a kitchen, a company lunchroom, or a bulletin board. And the third thing about the law is that there's penalties for employers if they don't do this now. For the first offense, if an employer doesn't give proper notice, they can be fined $500. And this would come from the Attorney General of the state of New York. Second offense, the fine is $1,000. And the third offense, and any further offenses after the third one, is $3,000 per offense. So employers need to be on notice of this rule or else they can be penalized. Also want to tell you about our friends, I want to speak to my friends in Connecticut. Let me put it that way. The state of Connecticut was way ahead of New York. They have pretty much the same law already, and they've had it for about 20 years. It was the late 1990s when the state of Connecticut put in pretty much an identical law that New York just put into effect only a month ago. So Connecticut, you've been protecting your employees a little bit better than New York for the last 20 years. Got one last thing, which this is my tip to employees. I think a lot of you probably didn't know. If you're out there listening, you're an employee like I didn't know 20 years ago. Your employer can look at your emails. They can listen to your phone calls, and they can check your internet searches. So just play it safe. Most employers are pretty cool about employees using devices for important things with their family, emergencies, things like that. You can do it a little bit, but don't take advantage of it. If you have to do an internet search on a personal issue, or you need to make a phone call or an email that's very personal, like dating and things like that, just do it at home. I've seen bad things happen when people have done that. They get involved in lawsuits, and all of a sudden, all their internet searches for the last 5 years are known by the employer. And nobody wants that. So just play it safe. Do all your personal stuff at home. Thanks a lot. My name's Jack Malley. Appreciate your time. And we'll see you on the next episode of Making Employment Law Simple. Take care.